Start. Whether an individual's control over such cardinal element of identity could be denied to him/her by the Central Board of Secondary Education on the specious ground that its examination by laws of 2007 must prevail over the claim of the candidate, which are merely intended to regulate such a claim and to delineate the procedure for correction/change in the contents of certificates issued by it, including regarding maintenance of its office records. Para. The CBSE examination bylaws restrict both qualitatively and quantitatively the corrections/changes that can be carried out in the certificates issued by the board. Various students with need-based requests approached different high courts, resulting into inconsistent outcomes leading up to this batch of appeals. Apart from the fact that the judgments have produced conflicting outcomes, the petitions raise some peculiar questions on the constitutional validity of CBSE examination bylaws (as amended from time to time) and interpretation thereof. Para. The present case involves a batch of 22 petitions relating to correction/change in name/surname/date of birth of candidates of their parents in the certificates issued by the board have been raised. The Supreme Court in the ultimate analysis found that the real dispute requiring resolution is about the nature of correction or change, as the case may be permissible to be carried by the CBSE at the instance of the student, including past student. The Supreme Court found two situations would arise. Para. The first is where the incumbent wants within double quote correction in the certificate issued by the CBSE to be made consistent with the particulars mentioned in the school records. As we have held, there is no reason for the CBSE to turn down such request or attach any precondition except reasonable period of limitation, and keeping in mind the period for which the CBSE has to maintain its record under the extant regulations. While doing so, it can certainly insist for compliance of other conditions by the incumbent, such as to file sworn affidavit making necessary declaration and to indemnify the CBSE from any claim against it by third party because of such correction. The CBSE would be justified in insisting for surrender/return of the original certificate or duplicate original certificate, as the case may be issued by it for replacing it with the fresh certificate to be issued after carrying out necessary corrections with caption/annotation against the changes carried out and the date of such correction. It may retain the original entries as it is except in respect of correction of name effected in exercise of right to be forgotten. The fresh certificate may also contain disclaimer that the CBSE cannot be held responsible for the genuineness of the school records produced by the incumbent in support of the request to record correction in the original CBSE certificate. The CBSE can also insist for reasonable prescribed fees to be paid by the incumbent in lieu of administrative expenses for issuing fresh certificate. At the same time, the CBSE cannot impose precondition of applying for correction consistent with the school records only before publication of results. Such a condition, as we have held, would be unreasonable and excessive. We repeat that if the application for recording correction is based on the school records as it obtained at the time of publication of results and issue of certificate by the CBSE, it will be open to CBSE to provide for reasonable limitation period within which the application for recording correction in certificate issued by it may be entertained by it. Para. However, if the request for recording change is based on changed school records post the publication of results and issue of certificate by the CBSE, the candidate would be entitled to apply for recording such a change within the reasonable limitation period prescribed by the CBSE. In this situation, the candidate cannot claim that she had no knowledge about the change recorded in the school records because such a change would occur obviously at her instance. If she makes such application for correction of the school records, she is expected to apply to the CBSE immediately after the school records are modified, and which ought to be done within a reasonable time. Indeed, it would be open to the CBSE to reject the application in the event the period for preservation of official records under the extant regulations had expired and no record of the candidate concerned is traceable or can be reconstructed. In the case of subsequent amendment of school records that may occur due to different reasons, including because of choice exercised by the candidate regarding change of name. To put it differently, request for recording of correction in the certificate issued by the CBSE to bring it in line with the school records of the incumbent need not be limited to application made prior to publication of examination results of the CBSE. Stop.